Oh,
Oh, all right, Mr. Roberson, we're back on the record. You're still under oath. And we're gonna continue with the questioning. Have you had enough time to speak with your attorney,
Yes.
Mr. Joe Apt, who's standing here with you today?
Ye-
About your case, including any possible defenses that you might have?
Yes, sir.
Do you need or want more time to talk to him about your case?
No,
before
sir.
Proceeding further with this guilty plea?
No, sir.
We took a break so that you could speak with him, right?
Yes, sir.
You've had enough time to talk to him?
Yes, sir.
Are you satisfied with his services?
yes.
Yes, sir.
Counsel, do you waive formal reading of the indictment, including any defects that may be in the indictment?
We do.
For purposes of the plea?
We do.
Have you gone over all of Mr. Roberson's rights with him, and did he appear to understand them?
I did, including his habeas rights. I've gone over all of his Boykin rights and he understands them.
Based on your investigation of the case and you've been speaking with your client, do you believe that he is both competent to enter this guilty plea and that we can and should go forward with it in light of what you said earlier about his medication and any other issue?
He's competent. I've had several conversations with him this week, met with him. He understands what's going on.
Mr. Roberson, do you remember being arrested on these charges?
Yes.
Yes.
The state is not aware of any outstanding warrants related to these charges. Are you aware of any?
There are none.
And let's see. This is what we call a non-negotiated guilty plea, which means that you, through your attorney in the state, have not been able to agree on the same sentence to ask of the court. The court will sentence you within the range that we talked about a little bit earlier. And once the court sentences you, you will not legally have the right to withdraw your plea if you don't like the sentence that you received. You understand that?
Yes, sir.
And you do have a sense of the sentence that the court will impose, is that correct?
Yes.
Yes, sir.
You understand this is a guilty plea that is permanently recorded on your criminal history.
Well, we're asking for first offender, but he understands.
Okay, but it's still going to be on his criminal history
We understand that.
Yes, sir.
for purposes of, prosecutors, judges, law enforcement will still have access to that. All right. Do you understand that this guilty plea may be used in aggravation and to enhance sentencing on future convictions in
Yes.
this jurisdiction as well as in other jurisdictions, including in the federal courts?
Yes, sir.
You understand that if you are placed on probation, you cannot violate the criminal laws of any governmental unit or any special conditions of your sentence without being subject to having up to the balance of your sentence revoked.
Yes, sir.
You understand that you're not allowed to possess or use a firearm while on probation.
Yes, sir.
You understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm or use a firearm in a crime, you will be guilty of a felony that carries a significant sentence that could be up to 15 years in prison.
Yes, sir.
You understand that if you are not a United States citizen, this guilty plea will affect your immigration status and will result in deportation.
Yes, sir.
You understand that the court, your attorney, the district attorney's office, none of us has anything to do with parole, the Department of Corrections, or the Board of Pardons and Paroles, and nobody can guarantee you parole.
Yes, sir.
Are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes, sir.
Have you ever pleaded guilty, nolo contendere to, no contest to, or ever been convicted of a felony in the state of Georgia or anywhere else?
No, sir.
Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
No, sir.
Has your attorney explained the First Offender Act to you?
Yes, sir.
You understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced up to the maximum sentence for each charge in this indictment to which you're pleading guilty today.
Yes, sir.
You understand you're waiving or giving up any and all defenses, including any mental health defenses, by entering this guilty plea.
Yes, sir.
Do you understand that by pleading guilty, you're giving up the following rights? The right to have a trial by jury, the right to remain silent and not incriminate yourself, the right to confront the state's witnesses against you and cross-examine them if you desire, the right to assistance of counsel hired by you or to court-appointed counsel if you could not afford an attorney and requested one at the trial of your case. If you wanted a trial, I'm sure Mr. Apt would continue to represent you throughout trial. You also have the right to the presumption of innocence, the right to testify on your own behalf, and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. You understand all of these rights that I've explained?
Yes, sir.
You understand that by pleading guilty, you're giving up all of these rights?
Yes, sir.
Has anybody forced you or threatened you in any way or promised you anything to cause you to enter this guilty plea?
No, sir.
Are you entering this guilty plea freely, voluntarily, knowingly, and intelligently?
Yes, sir.
You understand that you may only have a limited right to appeal this guilty plea conviction?
Yes, sir.
You understand you'll only have 4 years from today to file a habeas corpus petition challenging the voluntariness of this guilty plea.
Yes, sir.
Are you entering this guilty plea because you have decided that it is what you want to do after discussing the case fully and to your satisfaction with your attorney and thinking about the case yourself?
Yes, sir.
Mr. Terry Roberson, in indictment 25 SC 001582, how do you plead to count 1, trafficking in methamphetamine? Guilty or not guilty?
Guilty.
Are you in fact guilty of that offense?
Yes, sir.
How do you plead to count 2, possession of a firearm during commission of certain felonies? Guilty or not guilty?
Guilty.
Are you in fact guilty of that offense?
Yes, sir.
How do you plead to count 3, possession of firearm during commission of certain felonies? Guilty or not guilty?
Guilty.
Are you in fact guilty of that offense?
Yes, sir.
How do you plead to count 4, possession of firearm during commission of certain felonies? Guilty or not guilty?
Guilty.
Are you in fact guilty of that offense?
Yes, sir.
And just for purposes of the record, I see that your attorney was assisting you in answering the questions. I just want to make sure that you understand everything that's going on here today, Mr. Roberson.
Yes, sir.
And are you sure this is what you want to do?
Yes, sir.
And Mr. Apter, are you in agreement with that Mr. Roberson does understand everything and that he is entering this guilty plea freely, voluntarily, knowingly, and intelligently?
I am. He's competent and understands what's going on, and we've discussed it at some length, both today and previously. And we've reviewed all of his possible defenses, motions to suppress, all of those kind of things that we could potentially raise. He understands he's waiving his right to a jury trial, and he's doing so intelligently and freely and knowingly and voluntarily.
And we are scheduled to be first out for trial on December the 1st, and he's choosing instead, based on your conversations with him, to go ahead and begin the guilty plea. Is that right?
That is correct.
Your Honor, the state tenders the plea, and we submit the facts that the state said earlier. Everything happened in Fulton County, and the state is requesting a sentence of 15 years on the trafficking in prison and the minimum fine, which is $300,000, and then consecutive 5 years probation on count 2. So that'll be.
So you, as long as I do 20 to serve 10, you're okay with everything else?
Yes, Your Honor. I have some mitigation to present to the court. I'll be brief, but
Okay.
I want the court to be aware of some things, but we are accepting that. Absolutely.
And counts 3 and 4, those gun charges would merge into count 2.
I can't argue for it. The fine, Roundtree talks about whether you can probate the sentence. It doesn't say anything about reducing the fine. The fine's a mandatory minimum fine. So
Well,
And we all.
and I appreciate your candor with the court. I had a lawyer with great candor yesterday about an anti-litem notice about whether it had to be sent or received, and they changed the ruling, said it had to be sent. So I'm going to go along with the 10, and I'll take judicial notice you have mitigating factors. All right, sir, do you understand the nature of the charges against you?
Yes, sir.
You understand all the rights you voluntarily give up,
Yes, sir.
and you're giving up all those rights freely and voluntarily?
Yes, sir.
Do you have any questions of your lawyer or of the court?
No, sir.
I find the defendant's competent of the plea. I find the plea is voluntary. I will sentence, as previously stated, a global plea with the mergers of 20 to serve 10. He can turn himself in at 9 a.m. at 901 Rice Street on December 1st, 2025. And he'll get credit for any time he's been in. And I think that's it.
Judge, you're granting him first offender.
You understand the benefits and consequences of first offender?
Yes, sir.
I am granting you first offender.
I know it's a brief indulgence, but could I just, and I know the court doesn't have a lot of time today, but he's got a lot of family here who came and I just, if they could just stand up, there's a lot of his family is in law enforcement. He's got a big support in the community and they expected me to put a lot of mitigation on the record, Judge.
Well, we discussed this case at length in the back. And the problem is, I haven't seen this many guns and drugs and magazines in years. And we talked about whether or not I had discretion. The state initially said I didn't have discretion. I had to sentence him to 15. I'm using my discretion to cut him a break, and your lawyer has done a fabulous job. I have not seen this serious of a drug case in 20 years as a Superior Court judge. So I understand that you're here in support of him. I take judicial notice of that. And we have worked this case out, I think, fairly and justly.
Thank
Y'all
you
have a good day. Thank you.
so much, Your Honor.
Your Honor, I need the defendant's cell phone number. I will give him a call within the next 5 minutes for reporting instructions.
What is-
Mr. Ashton, you give that to me.
I
and I'll
can't.
send it to him.
What's your cell number?
Because we're also asking
404
that everything that was
375.
seized be forfeited.
199.
All right. Is that okay, Jay?
We stipulate to the forfeiture.
All right. Forfeited.
1994, 1994.
1 minute.
And approach with the.
We said
You may.
I get
Thank you.
the forfeit too.